So today I'm going to really go through who we owe a duty of care to as auditors through the use of these guys. So I just picked these guys up at IKEA. So let's put this one here, the little man. He can be our auditor. Here we've got our managers, the ones who prepare the financial information. Here let's have this person as a representative of the board of directors. We know the board represents shareholders, so let's have the shareholders over there. And then let's have our third party over here, the little witch. So between our auditor and management, we know that management are the ones that prepare the financial statements, and the auditor is the one checking what management does. We also know that the board of directors have oversight through corporate governance over management. And there is a contract between the board, usually the audit committee, and our auditor over here in the form of an engagement letter. So that creates a real relationship between the auditor and the board of directors. So if anything ever goes wrong between these two parties, they have the option to sue each other under contract law. Over here, we have the board and our shareholders. Okay. Now we know that our shareholders are not privy to the contract between the auditor and the board of directors. So how does the auditor owe our shareholders over here a duty of care? Well, they do that through the tort of negligence. And the tort of negligence says that under Donoghue and Stevenson, we may owe third parties, like these guys, a duty of care. Now, within our classes, we've gone through a number of different cases about duty of care. So London and General Bank, we've looked at AWA v Daniels, we've looked at Columbia Coffee and Tea, we've looked at Caparo, but the key one I'm going to focus on today is the case of Asander. Now this is an Australian case, so Asander is the High Court of Australia. So please note for anyone watching overseas, this video is for the Australian specific precedent. But Asander said there must be what we call proximity between third parties. So third parties are these people over here. All right, it's my shareholders and perhaps my other third parties like a lender or a government agency who use the report prepared by the auditor to make decisions. Now in this sample of the audit report from Qantas Airways Limited, you can see that the audit report very clearly says or is addressed to the shareholders of Qantas Airways Limited. Now, what the auditor is doing when they're specifically addressing the audit report is that they're saying, even though we have a contract with the board, we recognize that these guys are the ultimate users or the intended users of our financial work, so of our audit report and the financial statements. So even though there is no direct relationship between these two parties, the auditor owes these people over here a duty of care through the idea of proximity. So the Asander case really drove home the importance of proximity. Proximity means that there is a real relationship. Now we definitely know that there's a real relationship between the auditor and managers and the auditors and the board of directors, but the auditor doesn't really have any direct contact with the shareholder. However, the proximity, the idea of proximity, says that because we know that these guys over here are the users and we address our report to them, the auditor does owe our shareholders as a whole a duty of care. So therefore, we are liable to those shareholders under the idea of proximity. Where it gets tricky is over here with this third party. And in the majority of circumstances, this third party is normally a lender who has used the auditor's report, which was addressed to the shareholders. It was not addressed at all over here to the lender, and they use it to make a decision. And as a result, sometimes that decision goes bad. So does the auditor owe this third party who is not a shareholder a duty of care. Proximity and the related judgments from a number of different cases indicates that for there to be proximity, for there to be a real relationship between these two parties, the auditor must, and these are some good words I like students to remember, encourage, entice, or induce the third party over here to rely on the auditor's report. Now, we know that the auditor is encouraging or enticing or inducing the shareholders to rely on the auditor's report because they actually say in the report, this is for shareholders. However, if we go back to the Qantas report, you'll notice that the report does not say, dear lenders or other third parties. So therefore, for there to be a duty of care owed here, the auditor must encourage or entice this third party to rely on the financial statements and the audit report. It clearly doesn't say that within the auditor's opinion at all. So the only way in which this third party over here can be in a relationship with the auditor is through the idea of a privity letter. So a privity letter is a letter in which the auditor would sign and say, hey lender over here, my audited financial statements for these users is actually suitable also for your purpose. Now, auditors don't tend to sign those privity letters. We did have an old audit guidance statement that indicated that perhaps auditors should respond and say that's not possible. But it is very rare for this third party to have a real relationship and therefore proximity to the auditor. As a result, therefore, the auditor doesn't usually have a duty of care to other parties besides the shareholders.